Let's look at the Jane Doe versus Marilyn Manson case. We'll see, why isn't this case thrown out on the statute of limitations? Why is it Jane Doe? And are there any things that have happened in this case that could indicate to us clues of Manson's overall defense strategy and hope to conclude these cases? On the statute of limitations, I'd already made a video about that and how it applied to the other cases pending against Manson. One of those cases being thrown out, one of those cases being allowed under a discovery situation, and in another case for equitable estoppel. But in all those cases, the court never applied the new statute of limitations. It's always the old statute of limitations, and that's what happened in this Jane Doe case. So actually the case was thrown out on the statute of limitations. The court said, hey, the 2-year statute applies. You didn't plead things that would get you around the statute of limitations, so I'm throwing this case out. However, the court gave the plaintiff the ability to amend the complaint and refile it. So that's what happened in this case. Here, the lawyer made no mistakes on the second time and pled plenty of facts to support the discovery rule. You have to remember that when a court looks at a complaint on a request to have it thrown out on its face, they're looking at the facts that the plaintiff has alleged as if they're true. There's no credibility weighing, there's no assessment of evidence. You take the allegations, you assume they're true, and then you decide, did this person allege a cause of action, all the elements of it, in the way necessary to legally sustain that cause of action? And did they leave anything or put anything in the complaint that would allow it on its face to be thrown out by an affirmative defense? So that's what happened in this case, that the complaint as originally drafted, the court said, even if I take all this as true, you're still subject to the statute of limitations. This case is out of here. But the plaintiff's attorney amended the complaint and cured the things that the trial court had a problem with, refiled it, and we'll look at those alleged facts now. Before we do, remember, the court is not considering whether they're true or not. The court assumes that they're true. So they may be proven later on in the case to be false, or the plaintiff doesn't meet the burden of proof on these things or whatever, doesn't have evidence for it. And then the statute of limitations could come back into play even if it survives at the initial phase. That's also the case in the other cases that remain as well. So let's take a look at what these facts are. So the plaintiff alleges quite a long time ago that she was forced to provide oral sex to Manson and then also raped. But those things occurred long before the statute of limitations would have run. So how do you get around it? You invoke the discovery rule in California that says I didn't know. And so the statute of limitations should be told until such time as I had the opportunity to know this. Again, whether that's true or not is not the issue here. The issue is, did she plead enough facts to invoke this discovery rule? So in February 2021, the plaintiff says she heard a news story or was told about a news story about sexual assault allegations against Manson by other women, and this began to prompt things in her mind of what might have occurred with her long ago. So over the next several days, she said, she thought about the relationship with Mr. Warner. Then she remembered forced oral sex. She repressed this memory from July 3rd, 2011 at the latest to February 2nd, 2021 at the earliest. And it sounds ridiculous to say it like that, but the lawyer is trying to provide to the court the period of repression here and show that it occurred quickly after the event and then was dispelled and the memories came back within the current statute of limitations. So that's the point of that. On Friday, February 5th, plaintiff was taking a walk when she suddenly remembered the vaginal rape from 2011. She had repressed that memory from July 3rd, 2011 to February 5th, 2021. Then on March 8th, 2021, she spoke to law enforcement officers regarding her experiences with Warner. On the Sunday prior, when she was preparing for that, she remembered that Mr. Warner had made death threats to her following the rape. Now, does that sound credible to you? Do you believe that? Do you have an opinion on repressed memories? Let me do a quick sidebar on, for example, how much my opinion matters in the situation as to how the court applies the discovery rule. Are you ready? It doesn't. It doesn't matter at all. It doesn't matter at all whether I agree with it. The trial court said if you plead enough facts to show a repressed memory, then your case is going to be able to move forward. Now that, the jury can assess that later, maybe even the judge too under different circumstances, but this is just a matter of law. Can you get your complaint through the door and keep it in the courthouse? It was kicked out once. Plaintiff's lawyer kicked it back in by changing what he was alleging, and that's where we are. This case is still live. Second issue how come this case is called Jane Doe? That's not her real name. Why does she get to put that on the lawsuit? California statutes provide that the case should be prosecuted in the name of the real party in interest. That's not her name, Jane Doe, unless there's a statutory allowance for that. However, California courts have been pretty permissive in allowing people to use pseudonyms to file cases, especially if the allegations involve sexual assault or harassment, potential harassment, that sort of thing. And her lawyer makes the case that she should be allowed to proceed under this for those exact reasons, that it's a sexual assault case and that Manson's fans are lunatics who will harass her. Is it fair for the plaintiff to be able to hide her name or his name in a sexual assault allegation, but the person accused has their name out in the public? Is that fair? Why aren't they both anonymous? If you want to come anonymous, then the other person should be anonymous. It shouldn't be an unbalanced situation, right? Well, I have looked into it, and I can tell you how much my opinion matters in this situation. None. It doesn't matter at all. California courts are very permissive. I can see an unfairness there. I can also see the point that they're trying to get to, which is not causing undue embarrassment or further stigma to people who've been subjected to sexual assault. But I do think there is an interest on the defendant's side as well. They're pilloried in the public press based on anonymous accusations. Is that fair? Why aren't they both anonymous? I don't know. But it is what it is. Manson's lawyers have objected to this, saying they don't think she should be able to proceed with an anonymous name. But the court hasn't done anything with that, and I don't think anything is going to occur. So the statute, if you read it, would say clearly she should use her name. But if you're learning anything, you're learning you can't just read the statute. You have to look at what the courts actually do with it. That's was part of the fun of making law confusing. And when you look into the law, you find that the California courts are pretty permissive on this. They do allow this a lot. So I'm not surprised that the judge hasn't done anything about it here, and I doubt that the judge will. Now the bonus round, which is there anything in this case that provides some insight or interesting facts about the overall situation with Manson, even though the case really hasn't gone very far. And digging through the board and court documents, I think there is. The parties had a case management conference where they discussed the status of the case and provide a report to the court telling what they think the issues are, how much discovery or any discovery issues they see coming up, how long they think the trial will take. What's interesting to me in this case is that Manson's attorneys reported to the court that they had discussed and reviewed with Manson the possibilities for alternative dispute resolution, like mediation or arbitration or whatever. They had discussed that with him. And then Manson's attorneys indicated they were willing to go to mediation. They reported that to the court. And this led to what I think is a very interesting document, which is the court's order for the case management conference. And look at what it says. It says, the court orders the parties to mediation, possibly global. So the court's ordering you to a mediation, possibly global. What does the court know about the global mediation? I think that follows on some of the comments that at least one of Manson's attorneys had made, that if they could, that at some point in the cards, there might be a discussion on how to settle all these cases. Well, that came up in this court's order, that they are going to go to a mediation. The court's ordering them to do that, and maybe that will even be a global mediation. So again, I think some people think that the job of Manson's attorney should be to clear his name or hold the accusers accountable for their terrible behavior. Those are things that they'll do if they need to, or if Manson demands that they do it, they'll pursue those things. But the real objective is to win for him. And winning can be a lot of things. And winning is very rarely having to go in front of a jury and prove your case. I mean, Manson's in several cases now, and this means several juries. He only has to lose at one before he's found to be an abuser and have to pay a lot of money. Can you win all the time in front of every jury? Yeah, I don't know about that. So his lawyers are prepared to do that. The plaintiff's lawyers are prepared to go against him. But it's not an unreasonable strategy for Manson's attorneys to say, is there some way that we can corral this, get all these things into a box and try and deal with them all at one time and get this behind us in a way that will satisfy the plaintiffs enough to make the cases be over and allow our client to get on with his life and just move on. That's not an unreasonable strategy. They kind of even said it out loud, talking about the potential for a global settlement. That may disappoint some of his fans, but that's the reality of the legal system, and they would be remiss if they didn't pursue that option for him unless he just clearly demanded otherwise. It may not work. If it doesn't, it could head straight to the OK Corral like the Depp case did, where they actually had a trial. But you never know. In most cases, end up settling, so you still have to bank on that possibility. And it could occur here. Just thought it was interesting that the court mentioned that in the court's order. I hadn't seen that before. Thanks.